California recently created transfer on death deeds, but they come with a few problems attached to them. For starters, a transfer on death deed can be easily invalidated if you don't follow the very meticulous steps required to create those type of deeds in the first place. So, for example, it must be in writing, must be signed by the property owner, it must be notarized, it must be recorded within 60 days of signing it, and it cannot be used for a lot of different types of properties. A transfer on death deed is also not valid if the property is already owned either in joint tenancy or in community property with right of survivorship. Recording a transfer on death deed in that instance simply will not work. If you have a bad actor who's wanting to take advantage of an elder who's in a weakened mental state, a transfer on death deed is going to be all too easy of a method for that bad actor to take real property from the elder. The deed can be created online using forms you can find online. They can be signed and notarized in private. And then once recorded, they can't be challenged by law until the property owner dies. That means that transfer on death deed, in theory, could remain on the property for years before somebody who's the rightful heir of that property has the right to bring a contesting lawsuit. Transfer on death deeds may work very well if you have a well planned out estate, if you've sat down and thought about all the implications to your estate in filing a transfer on death deed, and they'll work well in estates where there's no abuse present. But for real life situations where people are susceptible to abuse, the transfer on death deed could be a real easy way for an abuser to take advantage of an elder.